free to accept him as judge if you're going to litigate. And I have done mediations. I have also done litigations, and indeed have some of them pending now. When people are going to litigate, one of the advantages, of course, of using a rent-a-judge is you have exclusive use of time. There is not the fact that a sitting judge will have many cases on calendar, and some cases showing up for that didn't expect to show up and pushing off the other case, and lawyers busily sitting around burning up money and not getting anything done. But with a sitting judge, he's yours. You've bought his time, and he sits down and decides the case. And almost invariably, the lawyers want you to decide the case exactly as you would if you were a sitting judge. That is, rule on their objections correctly. It's done on the record. Apply the law correctly. Write your decisions in an appropriate way. And they indeed have that right to do that, and certainly as a rent-a-judge, that's what I do.
I tell a lot of people, think of the old Lucille Ball episode where the pies are coming along and they're moving so fast they can't box them. It's the same thing with a courtroom in the courthouse. They have cases for that day. They have cases for the next day. Every day they're coming. How much time does a sitting judge have for your case? And your case may be involved millions of dollars. Somebody else's case may involve hundreds of dollars. It's the same importance to both people, and the judge has to be fair with the allocation of time. Sometimes both people aren't happy with the allocation of time, and they feel a lot of times don't get to say what they want to say. So in a private process, whether it's a private judge having a trial or mediation or some other form, everybody can get to have their full say, and they feel a lot better about it, even though maybe what they had to say wasn't relevant or wasn't persuasive, but they feel better when a decision is made or when they reach an agreement. They at least got to say what they had to say.
Right, so when we do the private judging, that's not confidential, right?
No.
Okay. But when we do the mediation, there is some confidentiality, and I know Wanda had some questions about confidentiality in mediation, so if you could go ahead.
I love this part because this is the part where I get to say Judge Denner and Ron Rosenfeld are not strangers to each other. There's a lovely story behind this when Mr. Rosenfeld evidently was in charge of a mediation, and Judge Denner was sitting on the bench, and Ron Rosenfeld refused to talk. He's the man who would not say anything. And Judge Denner, you were going to send him to jail. Is that correct?
That's kind of a bit of a stretch, but
jail is such a rough term.
It involved a case where one party to a mediation, Mr. Rosenfeld had done, said that although a written agreement had been arrived at, that the written agreement didn't correctly reflect their understanding, and as a result, the other side wanted to take a deposition, which is a process for eliciting testimony. In this case, of Mr. Rosenfeld, and so one of the issues is in effect when the other side had put the issue of whether this was a correct statement of their agreement in issue. Could they indeed do that? I felt they had to. The appellate court said no. The policy in mediation is simply too strong for that. The result is that they sent it back and said you can't use anything, and which means that even if you talked away from where Mr. Rosenfeld was, just because he wasn't sitting there, if you discuss the case with your spouse on the way to see Mr. Rosenfeld, and that information could not be used in court. So as a result, there was a great deal of testimony which both sides wanted to give that could not be received, period.
What actually happened, I remember a little bit better because I was sort of in the barrel, is that when they were arguing, Judge Denner said, well, I got a great idea. I'll just have Mr. Rosenfeld come in and tell me what happened, and I'll decide whether it could be used. Well, I wasn't going to be doing this, and I actually called up my malpractice carrier, and they said, well, this is not malpractice. And I said, well, if Mr. Denner threatens to put me in jail unless I talk, what am I going to do? Who's going to protect me? And I guess the thing is, well, you better appeal. Well, thank goodness one of the parties appealed, and the mediation community sort of got together and they filed briefs. And I'll tell you, when the decision came down that said Judge Denner was wrong, that mediation is sacrosanct, and there was no mediator was going to be able to testify or tell anybody what happened in that mediation room, I'll tell you, I felt a lot better about it, because I don't know. I remember Judge Denner sanctioned another lawyer once in a case a long time ago who didn't want to say how he got information in certain brief that he had filed. And I said, you know, I don't want to be made an example of, but I felt very good about it. But what Judge Denner said was true. It was a surprise to everybody, Judge Denner, the mediators, that the state said, that the appellate court said, the mediation was not only in the room, but it was everywhere until it ended, until it officially ended. So that raises a question of, well, when does mediation start and end? So if two people are just talking, are they mediating, or does it have to have more formality? I think it has to have some sort of formality. They have to have some sort of agreement, it could be written or oral, that says, we are now mediating, we're using a neutral, 3 parties in a triangle, or however else they're going to do it. That's the start of this mediation confidentiality. And it ends when either party says in some form of writing, or this mediation is over. And until that time happens, in the case of when we were talking about, apparently the parties are on their way to the courthouse to file papers, and they were still negotiating after they left my office. And the court said, well, when those papers got filed in the courthouse, that's when the mediation stopped.
So are there any exceptions to this pretty wide umbrella of confidentiality?
I think once you get the word mediation, no, there's not. Now, you can clearly see that it's not all that clear what mediation is. Just because there are 3 people involved, that can be a sitting judge and 2 parties. But we don't think of that normally as mediation. But when you look at it, that's all that happened in front of Mr. Rosenfeld, is that someone legally trained was trying to lead them to a particular area.
I have a question.
Yes.
So does that mean, I find this fascinating, I think this is great. So does this mean in mediation, the parties can be sitting there, and as long as they're in mediation, let's just say, for example, the husband and wife say, you know, the wife says, okay, I know you have those 2 hidden bank accounts over in Canada and Puerto Rico, and you can keep them as long as I can keep the house and the Jag, but I know where they are and how much money is there. And that's all covered because they're in mediation?
Well, what would happen is, let's say they fell out of mediation and they go to court.
Okay.
And the husband, in his paperwork, doesn't say anything about these bank accounts. He says, well, all we have is this house. We should sell it and divide it. And the wife, as in your example, says, no, 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 no. In mediation, he said he had these things. Cannot be used what he said in mediation. Well, let's get Mr. Rosenfeld or Judge Denner, who was the mediator. They'll come in and they'll tell you, well, no, you can't do that. The only way those facts could possibly be used is if the wife's attorney could have found out these facts and showed independent evidence, nothing having to do with mediation. And sometimes when people have money buried in their backyard, there isn't any way, because that's why they buried it.
That's one of the problems, that is that there's really rarely a solution that doesn't raise other issues. And for the lawyer or any party who's going into mediation, you got to recognize that that confidentiality can sometimes be a sword that's used against you. So now this, of course, mediation is a matter of agreement. And I don't know that it would be improper for you to say, well, I want to mediate, but on the other hand, if you say something, I want to be able to use it. There's no case or law that I know of that would say that you couldn't make that agreement as long as that was clear. I don't know if Mr. Rosenthal would agree with that or not.
You know, it hasn't come up. If I was the mediator and the parties said, we want to be able to use everything that's said in mediation as if it wasn't